Okay, I'd like to welcome all of you to our first Law After Lunch session in this year, the year 2021. I wish all of you who are following us Happy New Year. Greetings to Baku, of course. We have today a very good colleague with us who we know for some years already. If I say we, that's the law faculty and the Institute of Economic Law. As some of you might know, we have a close cooperation with two universities in Baku, the State University and ADA, another private university in Baku. And we are happy to have with us Farid Amadov today. Greetings to Baku, who is sitting in Baku actually, and will give today's Law After Lunch talk to us. The topic is on the Nagorno-Karabakh conflict, not in general, but with a specific focus, if I understand correctly, on proceedings before the European Court of Human Rights. So that will be very interesting for us. This is, of course, an academic talk, so it is not for us to make politics here or to judge on political decisions, but we will be focused on a public international law perspective, different aspects that were presented by us, by Mr. Ahmadov. Let me introduce very quickly to you Mr. Ahmadov. He is a lecturer at ADA University. He received his legal education at Baku State University and with a specialization in international law. After that, he was with the Azerbaijani National Academy of Science, received a PhD in law. That was before. He was in Essex, where he did an LLM in international human rights law, and afterwards, and that is more recent, University of Oxford and DPhil, a PhD under the supervision of my colleague Farid Amadov. That is quite impressive young career, and as I said, we are very happy to have you here on today's presentation. I leave it there. The floor is yours, and we are looking forward for your presentation. Please.
Thank you very much, Professor Titi and colleagues, for the invitation. It's indeed a pleasure and privilege to be invited to the Law After Lunch series, and in fact to be the first in the year 2021 to be addressing this distinguished audience. Now, this time I'm doing it online, but I pray for better times. I pray for better times that next time we meet and do it face to face. Now, the introduction, obviously the topic itself and the way Professor Titi introduced it, yeah, it's absolutely the case that the focus will be on the ECTHR, or the prospects, and what the ECTHR, how the ECTHR had dealt with the conflict in its jurisprudence before the peace agreement, or the agreement, the trilateral statement / agreement was signed between Azerbaijan, Armenia, and Russia. But obviously, I think an overview of the conflict might be relevant and useful for those who are not aware, or for those who might have been influenced or, to put it mildly, brainwashed by some media discourse during the conflict, during the recent conflict, or before that maybe. Now, therefore, I thought to make a few introductory points about the conflict per se, and some of the issues that the court had dealt before the resumption of the 27 September 2020 armed activities between Azerbaijan and Armenia. So there are basically two critical dates. It's the critical date of which predates the resumption of the armed activities and the court's case law regarding the conflict, and the date after the conflict started and what the court said about various aspects of the conflict in the course of the 44 armed activities, and obviously about what the ECTHR can do about this conflict. What is applications to be brought before the European Court of Human Rights, whether interstate or individuals versus the states, whether that is Armenia or Azerbaijan, or maybe Russia, actually. That's also a possibility. Now, I'd like to share a screen with you. I hope I'm skillful enough to do this, just to give an overview of the conflict. For those who don't understand, who might not have been exposed to this before, so these are the maps of Azerbaijan and Armenia, Armenia being yellow on the map. And you can see the red, the dotted line on the map. The dotted line was the were the territories under occupation. Now, I will not prejudge the legal situation, the legal assessment as to who they were occupied by, because that was what the court clarified, and I will deal with that when I analyze the case law. So this was the dotted line, basically shows is the boundary of the territories that used to be under occupation. Now, the territory in red, marked red, was the territory, or is the territory of Nagorno-Karabakh, okay? And the surrounding parts of the surrounding regions, the Kelbajar, Lachen, Kubadlı, Zengilan, Jabral, Fizuli, and Agdam, do not per se belong to Nagorno-Karabakh as an autonomous unit that used to exist within the territory of Azerbaijan. Now, if we are to take a quick overview, a very quick overview of the history, of very recent history. So under the Soviet Union and under the Soviet Constitution, the 15 republics that made up the Soviet Union, these were under the Constitution. This represented the Soviet Union as a union, a voluntary union of 15 republics. And under this Constitution of the USSR, more specifically Article 72 of the Constitution, each of the member republics, republics that compose the Soviet Union, 15 republics, they had a right to voluntarily, at their own will, to withdraw from that union, because at least on a paper, it was the union was voluntary. Now, that same right was not recognized under the Constitution and constitutional arrangements of that time for the autonomous units that existed within the republics, within the 15 republics, and Nagorno-Karabakh was not the only one. There was within Georgia and the Abkhazian problem and South Ossetian problem. These are these things that are leftovers of the Soviet past because they had some statuses within Georgia. There were some autonomous regions within the Soviet Russia too. So there were many autonomous regions with various statuses within the republics, but the right to withdraw from the Soviet Union was recognized only for the 15 republics under the constitutional. So that was the constitutional arrangement at the time. So each of these republics within the Soviet Union, they had administrative boundaries with each other. So Armenia had an administrative boundary with Azerbaijan. Azerbaijan had one with Georgia, which is in the northwest, basically, of Azerbaijan. You can see at the left-hand corner. And each of these republics had their administrative boundaries. After the disintegration of the Soviet Union, obviously, under the known Uti-Posidetis principle, these administrative boundaries had to transformed into the boundaries of the states. So the state of Azerbaijan was recognized within the administrative boundaries of that existed in the Soviet Union. So was Armenia and Georgia, and we became member of the United Nations within those territorial boundaries. Now, the conflict itself started in 1988, before the collapse of the Soviet Union, and there were appeals made by the population of Nagorno-Karabakh Autonomous Oblast region of Azerbaijan to the Supreme Soviet of the Soviet Union to be unified with Armenia. That appeal was rejected by the Soviet government. Now, the reason why this appeal was made, because the ethnic composition of Nagorno-Karabakh was predominantly Armenian. Now, having said predominantly, and I'd like you maybe, there are different sources that contain different information on this, but I think the best point of reference would be the decision of the European Court of Human Rights in Sargsyan versus Azerbaijan, where the court says that the composition of Nagorno-Karabakh, the bit that is marked red, as I said, was 75 Armenian, 22 to 23% Azerbaijani, and 1 to 2% other ethnic groups, Kurds and Russians. So after the collapse, so obviously the ethnic, because this was ethnically Armenian region predominantly, as I said, but there were some towns, for instance, town of Shusha, as I show you here, was exclusively Azerbaijani, and there were Azerbaijani living in other parts of Nagorno-Karabakh, as I said, up to 22, 23%. Now, obviously, the problem after the collapse of the Soviet Union, although yes, the issue of unification was raised, but it was easy said than done. Because as you can see on the map, there is no physical connection between Nagorno-Karabakh, the one marked in red, and Armenia. There is a region of Lachen that stands in between of Armenia proper and Nagorno-Karabakh region, which is marked in red. So in order to ensure physical connection, in order to connect it physically, what had to be done is obviously to get under control the territories that were surrounding Nagorno-Karabakh, which is marked in red, and that is Kalbajar, Khankandi, Kalbajar, Lachen, Gubadli, Zangilan, and these were the 7 regions, the Ardam and Fizuli, the 7 regions that surrounded Nagorno-Karabakh, which went under the occupation. Now, again, I'm not prejudging by whom, because there was a disagreement on who was occupying the territory. There was a point of difference between Azerbaijan and Armenia. Armenia argued that it had nothing to do with Armenia per se, but that it was rather the Nagorno-Karabakh Liberation Army, the self-proclaimed Nagorno-Karabakh Liberation Army, that managed to get under its control all the provinces, all the regions that were surrounding Nagorno-Karabakh, which were populated exclusively by ethnic Azerbaijanis. No Armenians lived in any of these provinces. That is not a contentious fact. It's accepted by both sides to the conflict. And around those parts of Azerbaijan were populated with roughly 750,000 ethnic Azerbaijanis, which had to flee as a result of the occupation. Now, it is based on this contentious point as to who occupies the territory. It is this contentious point that was clarified, and this is where the European Court of Human Rights eventually comes in, and I'm removing that now, the map. This is where the European Court of Human Rights kicks in first, after the ceasefire agreement that was concluded back in 1994. So the first phase of the conflict, which was basically between 1991 and 1994, the active phase of the conflict, the first, as we call it, the first Karabakh War, which ended by ceasefire agreement of May 1994. And then from May 1994 to a resumption of renewal of the armed activities, we have had the European Court of Human Rights making an assessment based on the application by, which I call a disguised application, because the reason why I'm saying that it was disguised application, I believe the purpose of it was different than to secure the individual rights, because the application was about the right to property of Mr. Cheragov. This is a famous Cheragov versus Armenia case. Mr. Cheragov claiming that his right to property under the European Convention on Human Rights, Protocol 1, Article 1, was violated because he was deprived of his possessions. He had no access to his property, so he couldn't have used it. Now, obviously, and seeking compensation in that case, or a restitution, whatever was possible. Now, obviously, and Azerbaijan was a third-party intervener in that case. Now, it's evident to me, at least, that the purpose was not to secure the right to property of that person. The purpose, rather, was to get a statement from the court as to what the situation on the ground was, as to who controlled the territory and who was occupying it. Because, as I said, this was a point of contention. This was a point of contention in different negotiations and so on and so forth. During that, the discourse was of that kind at that moment in time. Now, so the court basically eventually clarified the situation on the ground, and the court said that the territories, Nagorno-Karabakh, which is marked in red, and I showed it to you, and the 7 regions around it were being occupied by Armenia proper, by the Republic of Armenia, which exercises effective control over that territory. And in fact, the court drew a sign of equivalence with reference to the Hague Convention, a sign of equivalence between effective control and illegal occupation, and equating these two things. So this was the contribution, the first contribution, as far as Azerbaijan was involvement of Azerbaijan in the case as a third-party intervener and Armenia was concerned. The first, basically, the case that triggered the court, involved the court, was the Cheragov case. It had to do, as I said, with the question of effective control and attribution of the conduct of acts that took place within the territory, occupied territory, to Armenia proper and to no one else. Now, a very similar case was brought by Armenia, or other cases, not by Armenia, by citizens of Armenia, by people of Armenian descent, rather, of Armenian origin. This is the case of Sargsyan versus Azerbaijan and some other cases, which basically there were some disputed parts of the occupied territories. So the question was who was in control of those territories. And in Sargsyan versus Azerbaijan, the court established that a particular town or village of Gulistan was then controlled by Azerbaijan, and therefore it had to be liable for the violation of the right to property of Mr. Sargsyan. So at that point in time, before resumption of the military activities before the new start of the armed activities in September 27, 2020, we had basically the cases that primarily related to effective control and the right to property. Now, once the conflict erupted, anew again on September 27, 2020, which is the 2 days after the conflict, after the military activities resumed, we had Armenia requesting the court to indicate interim measures that in which it requested I'm going to summarize the request rather, where Armenia asked the court to order Azerbaijan that it stops indiscriminately attacking civilian population, civilian objects, and civilian settlements. So this was the gist of their request. Now, interestingly, I actually was very surprised when I saw that requests being submitted to the European Court of Human Rights by Armenia, because my gut feeling was telling me that, especially 2 days after conflict started, like dust not being settling after the earthquake, it was very unlikely for the court to point at Azerbaijan and say, you have to stop doing this and that and that. Given that the situation on the ground was very much unclear. It's 2 days after the conflict had started. So I expected that this would backfire against Armenia, and it did, because in its request, in its order for interim measures, the court called upon both parties to the conflict, Azerbaijan and Armenia, to refrain from acts that create a risk of causing irreparable harm, and that may lead to the violation of Articles 2 and 3 of the European Convention, the right to life and prohibition of torture. So this was addressed to both sides of the conflict, and in the few days later, sometime later, then few days later, I think it was almost a week later, Armenia filed another request to the court, to the European Court of Human Rights, requesting new interim measures, now this time, interestingly, vis-a-vis Turkey. Vis-a-vis Turkey, again, asking the court that the Turkish involvement that may potentially be detrimental to the rights and freedoms under the convention be stopped. And interestingly, the court did rule on the interim measures, and it ordered this time, it gave an order of interim measures, and in its order of interim measures, the court noted the following, saying that all the parties, whether all sides to the conflict, directly or indirectly involved, including Turkey, should refrain from acts that are to jeopardize, that may cause irreparable harm. So now this was by many interpreted as an indication by the court of Turkish direct involvement in the conflict. Now, my interpretation of the order of interim measures was very different. And in fact, and this is confirmed by the request by Turkey, or rather a decision of the court as a result of the request by Turkey to lift the interim measures, in which the court explicitly notes that the purpose of the order of interim measures upon the request by Armenia against Turkey, vis-a-vis Turkey, was not to address Turkey per se, but it was to address any party, any side that is directly or indirectly involved. And direct involvement referred again to something that was already confirmed, the direct involvement of Azerbaijan and Armenia, and indirect involvement of Turkey, which Azerbaijan never denied, obviously. But there were others that were equally involved. So this was Turkey involved. There was, at least of the parties to the European Convention, Turkey was involved on Azerbaijani side, indirectly involved. This is a known fact. Russia was involved on Armenian side, and that's why the broad wording of the court's order of interim measures. Otherwise, it would only point at Turkey and without referring to all other indirectly involved parties. So Russia involved, and there were obviously states, non-parties involved too. On Azerbaijani side, we had Israel involved. On Armenian side, we had Iran involved. So there were stakeholders that were involved on both sides. Now, obviously, and then, so this was the court's involvement as far as the Turkish involvement in the conflict was concerned. But interestingly then, in the late October, I can't remember the exact date, Azerbaijani government submitted a request to the European Court again. So European Court of Human Rights was basically used as a tool by the conflicting sides, against one another. So Azerbaijan submitted another request, a request to the European Court of Human Rights, now to indicate interim measures vis-a-vis Armenia. Now, this also came to me as a surprise at the moment when I heard that the authorities decided to submit a request to the court, because to me the court had done that was a moot request, and because the court has already expressed its view and asked and ruled its order, gave its order of interim measures addressed to both sides of the conflict, and this was a futile act serving no purpose. And obviously the court's potential decision or new order of interim measures would also serve no purpose, because it said what it said. And this expectation of mine came out to be true, and that is, as a reply to Azerbaijani request of interim measures, the court noted explicitly that it's basically a moot request. There is no point of addressing this issue again. This is an issue which the court had already addressed. Now, the first request by Turkey to lift interim measures was rejected by the court, but Turkey in late November, I think November 26, submitted a new request to lift interim measures that were indicated vis-a-vis Turkey then at the time of the conflict. And the court this time satisfied its request and lifted order of interim measures vis-a-vis Turkey, taking into account a new circumstance, and that circumstance being agreement concluded between the trilateral agreement, tripartite agreement between Azerbaijan, Russia, and Armenia. But it states in that same decision on lifting interim measures vis-a-vis Turkey that the interim measures vis-a-vis Azerbaijan and Armenia shall remain in force. So perhaps taking into account that the hostilities may somehow resume, or in some other form, the military action may take many different forms even from now. So the court didn't want to take the risks, perhaps. Now, so this is the involvement of the court so far, up until today. Now, what are the prospects of the court's involvement in the months to come or the years to come? I think there are prospects of the court's involvement on a number of fronts. Obviously, if the parties trigger the court, involve the court. This is first at interstate level. At interstate level, but there is a potential for interstate proceedings. But most, I believe, would concern the right to property. Now, there have been multiple cases brought before the European Court of Human Rights, which are now still pending, relating to the right to property in the occupied territories. But I think the situation after the liberation of the lands, the facts on the ground are much clearer to the government of Azerbaijan, and it's much easier to assess the damage done to the property now, and obviously the claim of compensation might be much more substantiated one. But I'm not sure whether the government will proceed to directly tackle in the interstate proceedings those issues, or this will be more encouraging individuals that used to live in those liberated territories who are now with difficulties, obviously, because many of those territories have been mined. So now they can assess what is the damage done to property and then file individual claims against Armenia. So these are as far as the Azerbaijani internally displaced persons are concerned. Now, but on the other hand, we also have, there's a potential for cases to be brought against Azerbaijan, and these are by Armenians that had to, for instance, if I share the map again, so if you see at the part that is marked red, at the bottom of it, at the end of that red, there's Hadrut, a town of Hadrut. So you see Shusha, and then town of Hadrut. So the town of Hadrut, now Azerbaijan, and we'll come to which parts of the territory now Azerbaijan controls. Well, maybe I should say that now. So Kalbajar is under Azerbaijani control, Lachen is under Azerbaijani control, Gubadli, Zangilan, Jabrail, Fizuli, and Avdam are now under Azerbaijani control. So Shusha is now under Azerbaijani control, and Hadrut is fully under Azerbaijani control. So Shusha was, from the outset, from Soviet times, was populated exclusively by Azerbaijanis. But the town of Hadrut was not. It was populated by Armenians. So, and as a result of the military action, when the territories were liberated, the population of Hadrut, which is of Armenian origin, they have lived there since Soviet times, in fact. So they have fled from the territories, and that territory is now under Azerbaijani military control, and there are no Russian peacekeepers in that territory. I will show you very soon on a different map where Russian peacekeepers are dislocated. So now, depending on the actions of Azerbaijani government vis-a-vis the property that is located, for instance, in the town of Hadrut, there is a potential for cases to be brought against Azerbaijan by people that neglected, that abandoned their property, for instance, in the town of Hadrut. Now, if Azerbaijan acts wise and hands over, or rather, simply makes a statement, which so far the president of Azerbaijan has made, that these properties belong to the people who lived there, but this surely applies only to legal settlers, not illegal settlers, because there is extensive evidence of illegal settlements that were created in the occupied territories, and many Armenians from the Middle East, Lebanon in particular, were brought in and were illegally settled. So we are not talking about the property of those. Those were obtained as a result of breach of international humanitarian law. But those, like the ones that lived in Hadrut, they obviously have every right to enjoy their property under the European Convention on Human Rights, and Azerbaijan must guarantee and secure that right. So if we fail to do that, I think there is a huge potential of cases against Azerbaijan coming from Armenians who fled, who abandoned their property on that territory. Now, a big, huge gray area for me now, and for many of us, is related to, and I'll go into another map, which is the, and I'm sorry about this, I couldn't find an English version of it. I only was able to find a Russian version of it from the Russian Ministry of Defense. So this is the map, basically, of Nagorno-Karabakh that is now under control of Russian peacekeepers. Now, control I'm using in a very narrow sense of this word for the purposes of peacekeeping. So the line, the thick blue line that you can see, so the Russian peacekeepers, and then you see at the bottom and different parts of that territory, there are triangles, various triangles. So these triangles are the posts of the Russian peacekeepers, where the Russian peacekeepers are located. So you can see, it's Cyrillic, I'm sorry, Shusha on the bottom of it, but then you have parts of the territory that are still not under Azerbaijani control. Now, under the agreement, some say of 9th November, others say of 10th November of 2020, the tripartite statement agreement, the Armenian armed forces have to withdraw from the occupied territories with the arrival of the Russian peacekeepers. Now, to what extent this has happened and how much of the regular Armenian armed forces remain within the territory that is marked blue or within this thick blue line is unknown. Obviously, the authorities, the self-proclaimed of Nagorno-Karabakh, they're still there on that territory. The self-proclaimed president of that entity still claims to be the president of that territory of the Nagorno-Karabakh, self-proclaimed Nagorno-Karabakh Republic. And to me, there is a huge question now arising as to what will happen with the violation of the rights within that territory, because the peacekeeping, the mandate of the peacekeepers, the document stating out the peacekeeping mission, what their rights and duties are, is not available. I don't know if it is signed, but we haven't seen it at least. And what degree of control Russian peacekeepers are exercising there is also very much unknown. So therefore, to me, a huge gray area at the moment is the potential violations that may occur on that territory, violations of the human rights. So who is going to be accountable for those, liable for those under the European Convention is a big question, because Azerbaijan does not exercise any effective control over that territory at the moment, in any sense of the word. The boots on the ground are the basic army, Azerbaijani army. Not a single soldier of Azerbaijani army is there, has set his foot on that territory. So it's basically in a way controlled by Russia, partially, but to what extent, what is the division of responsibilities, the local authority and Russian peacekeepers is still unknown, at least on a document, as far as the legal grounds of it are concerned, the documentation is concerned, it's unknown to us. Now, maybe it will be clarified today, because as I speak, there is a meeting, trilateral meeting of the presidents of Azerbaijan and Russia and Prime Minister Pashinyan of Armenia in Moscow now. I hope this will clarify many of those issues, but up until now, it's still unclear. I think one more potential for adjudication, for claims to be brought before the European Court of Human Rights, that is on Armenian side. Now, as the military activities started, the parties, both parties to the conflict, had enacted martial laws and then submitted derogations under the Article 15 of the European Convention to the Council of Europe. Now, a week after the military activities ended, Azerbaijan, almost a week after or a little more, Azerbaijan had abolished the martial law, but it still remains in force in Armenia. I think its force was, legal effect was extended up until February, mid-February, if my memory serves well. And obviously there are issues within Armenia now that they need to tackle, which might potentially violate the rights of individuals, of Armenians, whether relating to the freedom of assembly, because that is something that Armenia had filed a derogation to, freedom of liberty, and some other rights. Now, Article 8, I believe, if my memory serves well. Now, this raises a question as to the legality of the derogation, given that the derogation was a consequence of a prior unlawful act by Armenia, which is now an unquestionable fact, because the agreement to which Armenia has become a party explicitly says that Armenia is to withdraw its armed forces from the territories. It was known to us before too. Now Armenia is to return several regions of Azerbaijan and to withdraw its regular armed forces from Azerbaijan. So it's beyond any doubt that Azerbaijan was occupied by Armenia proper. And given this circumstance, there is a question as to whether Armenia's derogation is a valid derogation because it's based on a prior unlawful act of an occupation of another territory, because the invocation of Article 15, the war and emergency, this was the basis for applying derogation and for enacting the martial law. So I believe there is a potential, if cases are brought before the court by Armenia, some of the applicants regarding violation of their rights, individual rights that were limited as a result of the derogation, some of those individuals actually may question the legality of the derogation itself, given that it was based on a prior unlawful act. And as Article 15 requires that the derogation must be in accordance with other obligations of the derogating state under international law. So this is a recap of my presentation. I think I'm just 2 minutes behind. I think I was given like 30 minutes or something around it. I tried to fit within the time. So I hope I've succeeded at least in doing that. So I've finished my presentation and I'm up for questions, if any, obviously.
Farid, thank you very much. This was an excellent presentation, gave us a wonderful overview on, in general, of course, the conflict, but specifically on the human rights issues, right to property, derogation, and other issues, which are, of course, if we take it from that side, classical topics for law students as well. Besides all the political importance and, of course, the dramatic situation, this is also an important aspect on general legal education perspective. Maybe I think you made the point here and there, but if you could nail it down, what do you think? How much influence actually so far did the European Convention on Human Rights had on the negotiations on a ceasefire and solution of the conflict? Did it have any impact? Did it play any role in politics, in military and political decisions? I don't know whether you can give an impression, because you're way closer to the situation than we are, maybe on that. Because for international lawyers, the impact of international law is, of course, a very interesting question always.
Yes, I think it's a very important and valid question. And we always need to look at how much law changes the political discourse, obviously. And I've witnessed a change in political discourse, especially after Cheragov. So obviously, Cheragov case very much influenced the change in political discourse on the Azerbaijani side, because up until the Cheragov case, the only point of reference for Azerbaijan were 4 Security Council resolutions, which were terms in very vague, which was couched in very vague terms in many respects, as many political texts are. So, and was amenable to multiple interpretations. And hence this decision by the European Court on Human Rights in the Cheragov case, that informed the change in the discourse and on the negotiating table on the Azerbaijani side, and obviously in its interaction with international organizations, saying that now we have a judicial body, the most reputable judicial body, which is making a reasoned analysis of the situation on the ground and telling us who controls the territory. It's no more Azerbaijanis who are interested in who are an interested party who are making this claim. Now, I'm afraid, as far as the interim measures bit was concerned, that least concerned any of the sides during the ongoing conflict. After the 27th September, the interim measures, the request to cease the hostilities.
It was, of course, on the height of the conflict, on the military
Yes,
conflict.
absolutely, which was right in the middle of the conflict, and I don't think anyone was planning to heed the court in the middle of the armed conflict. So there are there is a bit of taking into account, and there is a bit of ignoring what the court said.
I think you made the point. We don't want to go too much into politics, but we of course appreciate very much to have somebody speaking right from Baku to us. Are you, let's say, optimistic that the human rights situation, which is of course an important, very important aspect of the entire conflict, will now improve, or will we see some, let's say, human rights dangers for the remaining, for at least a certain period of time because of a certain unclear situation? You mentioned who is actually in control of the territory, and it is hard to actually point out to somebody who is responsible for human rights. So I don't know. I mean, who is responsible right now? And is the situation as it is right now a situation that is good under human rights consideration, or is it something we have to look carefully on?
I think at the moment, because at least as far as some of the territories that are now under Azerbaijani control, especially part of the territories where Armenians used to live, and I mentioned Hadrut. Well, there is no concern about human rights now because Armenians are simply not there. Now, that in itself is a human rights concern, obviously, because they should be coming back. And I think not should be, they must be coming back. Obviously, these are the places they've lived for a very long time. Now, and I think, again, I'm not to assess the political statements of the leadership of the country, but I am simply quoting what the leadership is saying, that they are going to guarantee the rights of those who had lived there. Now, it's surely easy said than done, and we have to be aware of that always. Now, because it's the process of healing and reconciliation and trust building is not something that happens in a blink of an eye. We need to understand that. But I think the government is determined to build that confidence. And I think that the agreement provides for a basis for that, the agreement, because part of the agreement is to open up all the communication between the two countries, so Nakhchivan, so all other parts of Azerbaijan, and now Azerbaijani government, I think being the richer side compared to Armenia, is investing heavily in building the railways, in the roads, connecting Armenia. And I think once the economic side of it is tackled, I think this is not going to be a problem. But we really have to be aware of that. We really have to be aware of that.
An interesting point that is underlying your argumentation is, of course, reconciliation is what has to be done, looking at the long history of this conflict. And reconciliation for a long time has been seen not so much under human rights consideration, but on a more general abstract basis from the perspective of society. maybe in your presentation today, the cases before the court on the right to property and other issues are a good starting point to bring human rights more into reconciliation as a process that is the most important, I would say, for the entire region. That is a challenge now.
I'm sorry to interrupt you. I think I was trying to convey a message that it's important that we as a government, the Azerbaijani government, the authorities, actually set up working efficient mechanisms internally, tailored mechanisms that would guarantee the rights, that wouldn't make the Armenians living there come to Baku to sort their issues out. But right at the spot, efficient mechanisms that would expedite their document formalization process if the property deeds are needed. So everything very efficient, tailored for the needs of the Armenians that live there. And the world, it's possible to do it. It just needs goodwill and some investment, which is not much of investment, to be honest. So I think that way you can build trust more, and you can show that there is a desire on your side to do it, as opposed to, for instance, making people come all the way to Baku to sort their issues with documentation out, which is not efficient way of doing it, obviously. So that would be my approach to it, at least.
Very good. Thank you very much. And human rights are an important aspect in this. And I think, again, it was great to have this topic more focused as you presented it, because there was hardly anything in the news on the specific human rights issues. It was on the people, of course, but not in the legal sense of human rights. So thank you very much to give us this introduction.
Pleasure.
It was great having you here. All the best to you, to Ada, to our cooperation, to Baku, of course, and hope to see you soon this year after we solved other issues that are named Corona and so on. All the best. Thanks again. Also to our listeners, and take care.